So now part 2 on what to do if you're planning to do an estate plan for yourself or for a loved one. In our last video, as you remember, we did talk about assembling and organizing your information and your assets in order to meet with an estate planning attorney. Now, in the initial meeting with any estate planning attorney, they're going to take that information that you've assembled and organized and collected and begin to speak with you about what I phrase is the simple estate plan. And what composes a simple estate plan is basically 3 big documents. That would be your healthcare proxy, your power of attorney, and your will. Now, I've explained these documents in past videos, which you'll see in the links in the description of this video. Make sure you check those out. But with respect to a healthcare proxy now, that is a written instrument whereby you're going to appoint a healthcare agent, someone that you trust, a loved one, a friend, that's going to step into your shoes should you be unable to make your decisions medically. And that agent that you appoint is going to be able to speak with physicians, collect medical information about you, and make the decisions for you with respect to your health care. This agency only comes into effect if you're unable to make your decisions medically. Once you get healthy and you come out of the state that you're in, then your decision will govern what happens next, unless you're determined to be incompetent. And this agency that you create is only with you for as long as you're alive. Now, the next document that I typically will discuss with clients is your durable power of attorney. And this, once again, is a written instrument whereby you're going to appoint an agent called an attorney in fact, and this person's going to have the ability to handle your assets. That would be your investments, your real estate, your bank accounts, any other types of investments that you may have. And this person will have the power to deal with those investments. The idea behind a durable power of attorney now is should you be unable to make your decisions or it's not convenient for you to make your decisions concerning your assets, this person would be able to step in and assist you. And basically with this agency, it goes into effect as soon as you sign the document. In other words, it doesn't go away. And it's durable in nature, and it has some other general provisions in it, which will allow your attorney, in fact, to deal with government agencies like Medicaid, or in Massachusetts, it's called Mass Health, or be able to represent you in a court of law, whether it be the probate court for a conservatorship or a guardianship. So this is another agency that you would form, and it's only around while you're alive. Then the next document I'll discuss with clients will be the will. And the will is a written instrument whereby you're going to dispose of your assets at the time of your passing. And in a will, there are some requirements that are there in Massachusetts that have to be complied with. But in general, this document is going to be formed so that you're going to appoint a manager of your estate, once called an executor, now called a personal representative, and that person's going to step into your shoes as if you were still alive, pay off all of your expenses, and then distribute your assets the way that you so designate inside your will. Now, these 3 documents work together. It would be your simple estate plan. Now, there is one other document that I do mention, and it's a 1-page authorization for HIPAA, the Health Insurance Portability and Accountability Act. And this authorization would allow your healthcare agent to go ahead and receive your medical records. Once again, if you're in a state that you cannot request those medical records, this would give that individual the ability to get those medical records, whether you're being transferred to another hospital or in order to give them to another physician. Next, I will then discuss with you or your loved one, if you're planning to estate plan for a loved one, what are the ultimate goals here? Typically, I look at 3 basic areas. Once we look at the assets, we can usually determine whether there's going to be a potential estate tax down the line. In Massachusetts, there is an estate tax, for instance. Some states do not have an estate tax, but my state is one that does. If there's a potential estate tax, we could basically handle that with some form of trust. Now, once again, if you recall from past videos, which once again, the links will be inside the description of this video, a trust is a written instrument whereby an individual will designate a fiduciary, someone of high responsibility, called a trustee, to manage the assets that are contained inside a trust for the benefit of others, called beneficiaries. And as I simply explain it, a trust is like a container. You have to place items into the container, and it's going to be held there until some type of a triggering event occurs. Now, a trust is a good way to handle an issue like estate taxes. But if you or your loved one wishes to just avoid probate altogether, and all trusts avoid probate, then we would do what's called an inter vivos trust. And that inter vivos trust is like a trust that can be funded while you're alive or while your loved one is alive. And once again, assets would be put into the trust because it's like a container, like a holding vehicle. And it can be placed into that trust until your passing or until your loved one's passing. And those terms of the trust can be drafted like your will or your loved one's will. So that's another avenue that we could go down. And then usually the third basic avenue that we can discuss would be whether you or your loved one are concerned about nursing home or long-term care. Now, if a nursing home or long-term care benefits is a concern, then we'll discuss another type of trust called an irrevocable or irrevocable trust. And the reason why we use these types of trusts is they're very structured. You cannot change the terms typically or the people involved in the trust typically. And the idea behind it is if we're dealing with Medicaid down the line or if we're dealing with Medicaid concerns for the future, then you want to separate yourself or your loved one would want to separate themselves from the asset for a period of 5 years because there's a 5-year look back that we have to basically think about and plan for. So in a nutshell, those are the documents, the issues, the concerns that we look at in our first meeting for an estate plan. And the more detailed and organized you are or your loved one is coming in the door, the better the meetings go. Now make sure you check out the links that are included in the description of this video. Make sure you subscribe if you're watching me on YouTube in the lower right-hand corner. And make sure you like the video if you are watching me on Facebook. If you're watching me on YouTube, some of the prior videos that I've shot in the past will be appearing up here as well that are related to this one. Make sure you check those out as well too. Dave Ceruolo, CeruoloLaw.com.